All right, we'll go ahead and get started. Some more people may trickle in. Okay, welcome everyone to the public workshop on NOx reclaim amendments, Regulation 20. Before we get started, my name is Philip Fine. I'm the Deputy Executive Officer here at the District and the Planning and Rules Division. Please place your phones on silent or vibrate so we're not interrupted during the presentation or the question and answers. You're all familiar with the district. Restrooms are out that door you came in, straight down the hallway. And in the event of an emergency, we may advise people to either shelter in place or evacuate the building. If you evacuate the building, you can see the exit signs to the front and the back. So again, welcome to the public workshop. This is the official public workshop, so it's our time to hear your comments and feedback on the proposed rule. We released rule language a couple weeks ago and then revised it slightly. There was an error in the first version, so I hope everyone has had a chance to look at the revised rule language. It is still just proposed rule language. We had a working group this week and got a lot of good feedback, so we're already looking at those comments and suggestions and seeing what we can do to tighten things up a little bit. So why don't we introduce the folks up here at the front table, and then we'll get into the presentation. We'll start to my left.
Kevin Ariana, AQMD Planning and Rules.
Gary Quinn, Program Supervisor, Planning and Rules.
Tracy Goss, Planning and Rules Manager.
Barbara Baird, Chief Deputy Counsel, Legal Division, AQMD.
Susan Nakamura, Acting Deputy Executive Officer in Planning and Rules.
Danny Leong, Manager, Engineering.
Elaine Shen, Socioeconomic Analysis with the District.
So we'll go straight to the presentation. Tracy Goss will give the presentation. If you were at the working group meeting earlier this week, this will be very similar. We've added a few slides to reflect some of the comments we received this week, but bear with us. There may be some people here who couldn't make the working group meeting earlier in the week.
All right, thank you, Phil. Appreciate everybody coming out this afternoon. As Phil said, we did give a similar presentation this past Tuesday at our working group meeting. We did add a couple of slides. I do want to point out that after the presentation, we welcome everybody to come up, make their comments. We'd like for you to come up to the microphone because we're also webcasting, and the webcast itself will be recorded for viewing at a future date by anybody that is interested. So talk a little bit about the background of Reclaim. There's some of you in this room that were around back when Reclaim started in 1993, as well as myself and some of the folks behind me. Reclaim is a market-based program that started in 1993, and it establishes annual facility-wide NOx emission limits for NOx and SOx. It has the two universes for NOx and SOx, then there's two cycles that overlap each other, and the trading of RTCs is a key element of compliance under the Reclaim program. The cap and trade program allows that trading among facilities to allow them to choose the least cost method to achieve the emission reductions that are required through our attainment strategy. Initial allocations were based on historical annual emissions that were reported to the district and that were handed out to the facilities free of charge. At the December 4th meeting, as many of you know, was the last time Reclaim was amended. As a part of that amendment, we adopted a 12-ton shave that would be implemented over the next 7-8 years. And as a part of that, we did recommend at that time that there be shutdown provisions on an equipment and facility basis. The recommendations at that time were not adopted by the board. Instead, the board directed staff to go back to the working group to do a little bit more work to evaluate what the impacts would be, look at if there's any alternative proposals that should be examined, and then return to the board with either that same proposal or an alternative. The primary objectives of the proposal is to avoid the use of shutdown RTCs, to avoid putting in BARCT, best available retrofit control technology. It would also help us achieve a closer alignment between the treatment of shutdown, reclaimed facility shutdowns, and also with command and control for ERCs. And then it would further ensure that the program did meet the command and control equivalency that's required under the state law. But also it's really geared towards providing a fair treatment of the facilities with equipment that's not operated for an extended period of time, but is not permanently shut down. So we could have facilities that may be, having equipment that are just being shut down for a short period of time, but then they may anticipate starting that equipment up in maybe not just 6 months, but maybe 3 or 5 years. As a part of the process, after December 4th, we did receive 4 comment letters. We have had a couple of more working group meetings with regards to the shutdown provisions. And some of those key comments that we received is that, 1, reclaim is working, that the buying and selling of RTCs is fundamental to the success of the program, and that they should be able to sell credits from shutdown equipment without any kind of restrictions. And then any shutdown provisions should be limited to the entire facility and not the individual equipment. And that last one in particular is one we heard because the provisions that we're discussing today are for total facility shutdown, and we're not looking at equipment-specific shutdown. We did receive a couple of other comments from industry about focusing on the use of the shutdown RTCs, focusing on the use instead of the generation. Maybe restrict the use of shutdown RTCs at an existing facility that is not already embarked, and then also being able to treat multiple facilities under common control or common ownership as a single facility. And I'll be talking a little bit more about that latter one in a few moments. So the current proposal, as Phil said, was released on the 22nd. We did send out just the language for the shutdown provisions originally, and then we found a mistake, so then we resent it out on the 22nd. But in short, this is applicable to facilities and reclaim that permanently shut down, so we're not talking equipment level, and it's either demonstrated by the facility coming to us, saying that we're shutting down, we're going to turn in our permits, or the district or the executive officer, if you will, determines that a facility is shut down. And that's going to be done looking at annual reports, and I'll get into that in a moment. But one of the key points I do want to raise is that if a facility in reclaim did not receive an initial allocation, these provisions would not apply to them. But talking about the executive officer determination, the executive officer could go back and look at 2 years of APEP, the annual reports that are filed by the facilities, and if the emissions drop by, say, more than 90%, doesn't necessarily have to be 90%, but that's a possible number, then we could actually determine whether or not, and look further about whether or not that facility is shut down. But as I mentioned, there could be something going on at the facility that we're not aware of that has caused the emissions to come down where they're actually not intending on shutting down. So it could be a cyclical operation in conjunction with the equipment. There could be a delay in parts for repairs, particularly as it applies to some of these larger facilities. The equipment needs to be placed in reserve status for startup later, or there's emission reductions due to NOx emission reduction strategies. So maybe the emissions have dropped because the equipment has had additional controls installed and may actually meet BART or be very near the BART limits. And then if that is the case and it looks like the equipment is going to start back up at a later date, they can file a plan and go for what we call a planned non-operational status for a period of up to 5 years so that they're not being penalized for having those low emissions. But at that time, though, if they take that non-operational status, all the RTCs would become non-tradable at that point until the equipment became operational, was emitting again. But here again, we want to provide a fair treatment for all the facilities with operations that may be out of service but may not be shut down. Looking at how the calculation is going to work when we evaluate how much of RTCs need to be reduced in conjunction with the facility shutdown, we would look at the difference between the average 2 of the last 5 years, the highest 2 emitting years of the last 5 years, and compare those emissions to what the emissions would have been if that equipment was at BARCT. And then that delta is what would be reduced from the facility's initial allocation. So we're focusing here on reduction from the facility's adjusted initial allocation. If the facility received any offset credits through Rule 1304, those would also be deducted. So the reductions of RTCs, as I said, we're focusing on taking the delta down from what was the adjusted initial allocation. So we're not talking about any additional RTCs that may be within the holdings that are above that amount. So any of these allocated RTCs that have been sold prior to the shutdown determination would require the facilities to actually buy and retire to make up the difference if there was not enough being held at the facility to cover the delta or the reduction from their initial allocation. And then the requirements shouldn't apply to any shutdown or transfer of RTCs to other facilities. So what we're trying to do here is if you have two facilities that are under common ownership that are doing the same function, such as, say, power production, we wouldn't take the RTCs or do a shutdown adjustment and allow those RTCs under that common ownership to be transferred to the other facility to allow them to use the RTCs to meet their reduction obligations. Here's just I got a couple of examples of how this might work. Here is a generic facility that actually has actual emissions below its adjusted initial allocation, which is signified by the green line. And if you look at the historical, we have the highest 2 years. The average of those high 2 years would be 75 tons per year. When you look at what those emissions would have been if all that equipment was at BARCT, let's say that adjustment was 40 tons per year, or that amount was 40 tons per year. So the delta between what was actually emitted and what would have been emitted had they been under BARCT is 35 tons difference. So that 35 tons would then be deducted from the initial allocation. Looking at an example of where the actual emissions are higher than the adjusted initial allocation, looking at the past 5 years, in this example, the highest 2 years average out to be 255 tons per year. If we did a BARCT adjustment, let's say if BARCT was applied, the actual emissions would have been otherwise 100 tons per year. So we have a delta of 155 tons per year. Applying that delta to the adjusted initial allocation, as you can see on this chart, that 155 would have actually gone negative. And it's not our intention to go negative on the RTC. So in the future, all the adjusted initial allocations would become zero, looking now and on into the future. We did have a meeting of the Stationary Resource Committee in July where we received comments from the governing board members and members of the public. A request was made to estimate the quantity of RTCs that would be left in the market if all the larger facilities were to shut down, and then compare that to what was evaluated for BARCT back for the December 2015 amendments. So right now we're working on doing that evaluation for all the large facilities, what we call Table 7 and 8 facilities, and we'll have that at a later date that we're going to discuss, and I'll be talking about that future meeting here in a minute. So one of the things that we are going to do is, at their direction, is consider what are some of the options or other concepts for common ownership or common control that we can look at if you have two facilities that, for lack of a better description, are reliant on each other in terms of complying with the reclaim. So thinking about that common ownership or common control, right now we're proposing it based on a 6-digit NAICS code, but we could actually maybe look at something different. We could look at maybe SIC code. We're actually looking for suggestions from the community, from the facilities about how we could look at this common ownership or common control. If a facility is under common ownership and it shuts down, do we say, well, the RTCs transferred to other facilities become non-tradable? That's an option. RTCs could be only transferable to facilities that are already achieving at BARCT. So we're looking for feedback and suggestions from everybody with regards to this particular provision. But I do want to highlight an additional slide. As I said, we had a working group meeting on Tuesday, and at that meeting, it was a really good meeting. There was a lot of dialogue and things that staff feels that we do need to take some further consideration on some of the elements of our proposal. Here's just a list of a few of those. As a part of the executive officer's determination of a facility being shut down, the way the rule is written now is we would do that determination and then just go to the facility and say, hey, we find that you're shut down. So a request was made that we actually do some kind of a notification early on in the process so that the facility knows that we are taking this look. What's the effective date of the shutdown provisions? Do we do it as of the date of the rule amendment? Do we do we pick a date in the past and fix it on a place and time, or do we look at it into the future? How are the BART emissions being adjusted? So let's say, for example, a facility has some of their equipment that's already at BART. How would we look at those emissions, and how would that play into determination of what this delta would be? In terms of the date of future holdings that cannot be sold, what if the facility shuts down or a determination is made during the middle of a compliance year? You know, would you actually look at that compliance year, or would you actually look at the next full compliance year in terms of what kind of reductions are going to be made to the initial allocations? And then also, we had a suggestion to look at the facilities that are not on the table 7 and 8, which are those larger facilities, to maybe look at a de minimis. One of the reasons this was brought up is the potential resources that would take to deal with facility shutdowns. And if you start looking at smaller facilities, it could be a resource-intensive process. We will have an environmental assessment document. Now, we had a full environmental assessment that was done for the December 4th board hearing at the time of that amendment when we did the 12-ton shave. What we're doing here, since we already had proposed shutdown provisions at that time that were evaluated, the CEQA document for this particular alternate proposal, if you will, would be an addendum to that document. So we don't have any circulation requirements, but we will make that document available as part of our 30-day docs of our set hearing package. In terms of the next steps, we are asking for comments by August 28th, or August 26th, I'm sorry, which is just a couple of weeks away. We are planning on holding another working group meeting, and we've already tentatively scheduled one for August 30th. So if you can mark that, put a hold on your calendar for that. And we're looking to, as we go through this process, seek additional input regarding our proposal. We intend on releasing our 30-day documents, what we call our set hearing package, by September 6th in advance for an October hearing. We will be returning to our stationary source committee at their September meeting on September 16th to talk about any changes to the proposal, comments received, before we actually take this to the board as a public hearing on October 7th. That's our intended schedule right now. I know it's a lot of information to digest, but hopefully you've had an opportunity to look at the staff report and the rules that have been available online, saw the slides in advance. So here are the contacts, the key staff contacts with regards to providing questions. Gary Quinn, the supervisor of the team, Kevin, who's the primary rule writer, Barbara Radline will be doing the CEQA document, and then Elaine Shen will be taking care of the socioeconomic analysis for this proposal. So with that, I will turn it over to ask for anybody to come up and make comments, ask questions, make suggestions. And as I said, if you would come up here, because we are recording this, we'd like for you to tell us your name, your affiliation, if you would please, and we'll go from there. So thank you very much.
Thanks, Tracy. So since this is a public workshop, again, we're very interested in your feedback, suggestions, comments, and we're here to answer questions. It's not really a back and forth debate like a working group meeting may be or could be, but we're definitely happy to clarify and answer questions, and definitely the time to get your comments on the record. So with that, we'll open it up. We'll just, by show of hands, I'll invite people up to the mic. Anyone wish to make comments? Yes. Well, we actually, is the other mic working as well? Yeah, so we can have two people at a time and we'll just alternate.
Good afternoon, Kurt Coleman, Southern California Air Quality Alliance. I don't have specific comments today. I talked to Tracy before the meeting. I agree that the meeting on Tuesday was a very good meeting. It prompted me to start drafting written comments and suggestions, which I did and circulated to my members. I hope to be able to get these a letter with written comments to you by tomorrow or early next week at the latest. But it will address the significant issues that we discussed at the meeting, and that those of the issues that were up on the slide that we feel are significant will be addressed in our comments, so thanks.
Thank you. Yes.
Hello, I'm David DeVoe from Amerex Brokers. We have a question regarding enforceability. If the AQMD suspects a plant is closing, would you reject a pending trade from such a plant? So if they were going to go sell their infinite year block RTCs and you suspect them as a plant that's going to be closing in the near future, would you put the trade on hold or not approve it?
The way we're envisioning it would somewhat depend on the final version of the rule. Right now, the way we're dealing with that is a proposal that if that trade was made and there was an obligation to that went below their initial allocation, or above their initial allocation, that facility would be responsible for getting those credits on the open market and surrendering them back to us. So we wouldn't hold up that trade, but that facility, if they did shut down, would still have the same obligation whether they had sold those or not. So that's one way to deal with it, but we got comments that there could be some issues with handling it that way. So we're open to comments of another way to do it. The other way is you either hold up trades or you know, buyer beware. We've heard that comment.
Yeah.
So we thought this was the simplest, most straightforward way, not having to hold up the trades. We will say that you know, under planned non-operational status, we would probably not allow a facility to trade during that period. But there's other ways to handle those restrictions. So any suggestions, especially from the brokers who deal with this all the time, would be welcome.
Okay. So for example, a facility hasn't necessarily been emitting for the last 3 or 4 years, and then they execute a trade. Would that be an issue? No emissions, but they have RTCs, for example.
It depends where they are in the process. In theory, we would have already gone 3 or 4 years. We probably would have gone through the process of either determining they were shut down and coming to some conclusion there, or issuing that planned non-operational status. So at that point, it would become clear. If it's in this transition period, one comment we got on Tuesday was maybe they would be allowed to do discrete year trading up until that point, but not allow any infinite year block trades in that period.
All right. I did have one other question on your graph. Yeah, I guess it's your sample calculation, number 1. It'll be on slide 14. So the basic question I had is, see how it keeps curving down over time? Wouldn't it be after you do the initial reduction of 35 pounds, or I guess it was in your example, 35 pounds, wouldn't the line go straight out at that point in time, or why does it continue to curve down? It's just a, is it an odd?
This is reflecting the shave that goes on in the future that would have been approved back in December.
Okay, so it was just kind of to use an example of a facility that was subject to the shave.
After 2022, it'll be a straight line.
Okay.
This is what we're calling the adjusted initial allocation curve, essentially, right?
Okay. So, but if a company wasn't necessarily subject to the shave, that line would just go straight?
Yes. So if it was not a Table 7-8 facility, it would be a straight line after the last shave.
Okay. All right. Thank you.
Susan.
Susan Stark with Tesoro. You'd mentioned at the Tuesday workshop that a concern about common ownership or control might be if someone would purchase a millionth or some insignificant part of a company just to be able to claim that title. So that was one thing we thought a little bit about, and I think we'll still reserve right to give you other comments past today. But would something like a controlling interest or controlling ownership, like so it's at least 51%, that might be something to consider to define or refine the meaning of common control or common ownership. And then if you get that, I know you were also talking about facility definitions, but It would seem if you could just say reclaim facilities that are owned by the same company with a controlling interest or whatever. I'm sure Barbara could work out the appropriate legal terminology that perhaps that would help with that. And then I did want to just circle back. We talked a little bit about this on Tuesday, but about under the common ownership, there's a bullet that RTCs would only be transferable to facilities at BART, but that would be if you're going outside of facilities under common. Okay, just wanted to
And that's
verify.
not in the current rule language. That's something we're considering right now.
Right. Okay, thank you.
Any other comments or questions? Bill?
Oh, good afternoon. Bill Pierce, Boeing. I just had a question. On one of the slides, the comment was made about requirements shall not apply to facilities without an initial allocation. But I'm wondering how, for like our facility where we've actually, very long time ago, but we purchased streams of RTCs from facilities that were shut down. And how would those be treated in the long term? Or I guess, just trying to see how this language plays out with those type of transactions.
So the current language only, if there is going to be an adjustment of future year credit holdings, it's only going to apply to what we call the adjusted initial allocation. So if there's holdings above what your theoretical, that green line, there's a theoretical green line for every facility that existed in 1993, based on what they were initially given, the initial shave within the initial adoption, and then the 2 shaves since. So that's the maximum that we would adjust. So if you don't have any, if you didn't come into the program until after 93, your green line is 0. There's essentially no effect. If you've purchased credits well above that green line or never had a green line, this proposal does not necessarily want to adjust those, but we are considering some other language that I mentioned today, if there was transfer from common ownership or potential restrictions on future holdings, but not necessarily with that adjustment that we're proposing, that delta.
Okay, we're just looking at, we went out and purchased RTCs based on what we thought our future needs would be.
Right.
And so those were brought into added on to our initial allocation.
It's not, you don't add on to your initial
Or
allocation.
not add
Those
on,
are just
but
holdings.
it just becomes part of our holdings.
Your holdings.
Yeah,
So
part of your holdings.
we are currently looking at individual situations of the larger facilities to see where they stand in terms of where they are in relation to BART, where their actual emissions are, what their holdings are, and what the effect, if they say shut down next year, would be. And that's based on a comment we got at Stationary Source Committee from a board member. And there's not that many facilities that we can't estimate pretty much exactly the situation that most facilities would be in. So that's kind of an invitation too. If you'd like to come in and talk about individual situations under this proposed rules language, that would be great too, because that helps us put that information together.
So, okay, thank you.
Any other questions, comments, George?
Good afternoon, George Pianka, NRG. I did participate in the workshop, and by phone it doesn't translate great when you're on the phone, but one of the questions that I had posed was for a facility that's already at BART that has a shutdown scenario, and I think that was kind of depicted in Gary's slide, I think on 14.
We didn't have a scenario at BART.
Okay. If I look at
if you're at BART,
if I look at slide 14, so this is the initial allocation that facility would have, and it shows it being reduced to 2022 following the December amendments.
Yes.
And so the question I had is that would that facility, if it shuts down, is that initial allocation continue down its path of reduction along that line,
It will,
even though it has shut down, or is it, essentially go to zero?
if you're at BART, when we do the delta comparison between your actuals without BART and your actuals, your actuals and your actuals with BART, if you're at BART, that delta is zero.
Right,
There's
and you
no
don't
adjustment.
You don't adjust.
Right.
And so you would continue on that path of your initial allocation for that.
Continue to go down that path, and
facility.
in the absence of a subsequent shave, it would flatten out after the end of the
Right,
shave.
understood. And so one of the comments, I'm glad it came up, was about the rule itself. And so we certainly at Energy would support a effective date of the rule if adopted this year, and not a retroactive on, in particular, that means for sales, if facility sells credits, they're accepted, they've been approved by the district, and but that not go back retroactively in terms of going into your allocation and buying and retiring. So that's one comment.
Thank you. It would really depend on whether any of these facilities shut down in this previous 6 months, a year, or since the last shave. We'll look at that. That's something we're going to clarify. Any other comments or questions? Okay.
There is one thing I do want to clarify. When you look at the rule language, talking about facilities under common ownership, we were looking at choosing a freeze date, that of September 2015. So I'd be interested in any comments about any kind of a freeze date for determining whether facilities would be under common ownership, common control. So just something else to think about.
So if there's no other comments or questions, again, I would like to encourage anyone who has questions they want to ask offline, or come in and meet with us and talk about individual facility situations, that would be welcome. We're trying to get the comments in by August 26th, another working group meeting, and then we have a pretty fast turnaround time to get a staff report and a revised rule language out before our 30-day package is due in early September. So don't hold back, and if there's any questions, comments, or issues you have, please call us and come meet with us. Okay? If there's no other, George, you're raising your hand, but I know you're just demonstrating what a delta is. But okay, so if there's no other comments or questions, we'll call the workshop to a close. Thank you very much for your attendance. Thank you.